You're listening to the N2K Space Network.
The IT world used to be simpler. You only had to secure and manage environments that you controlled. Then came new technologies and new ways to work. Now, employees, apps, and networks are everywhere. This means poor visibility, security gaps, and added risk. That's why Cloudflare created the first-ever connectivity cloud. Visit cloudflare.com to protect your business everywhere you do business.
On June 28, 2024, the United States Supreme Court cut back sharply on the power of federal agencies to interpret the laws that they administer and ruled that courts should rely on their own interpretation of ambiguous laws instead, upending nearly 40 years of government practice. That seismic decision will have far-reaching effects across the United States, from environmental regulation to healthcare costs. And what about in space? Well, let's learn more about that. Welcome to T-Minus Deep Space from N2K Networks. I'm Maria Varmazes. Under the Chevron doctrine, if Congress had not directly addressed the question at the center of a dispute, a court was required to uphold the agency's interpretation of the statute as long as it was reasonable. But that ruling has now been overturned. I spoke to attorney Michael Listner about what he believed the knock-on effect will be on the space industry.
My name is Michael J. Listner. I am an attorney here in the state of New Hampshire. I'm a noted authority in the areas of outer space law and policy, among other things.
Very much appreciate your expertise and you coming on the show to walk us through a question in an area that I think a lot of people have been having since what I know as the footnote as the overturning of Chevron. That is sort of like pretty much all I know it as. When I heard about the ruling, I was going, okay, what on earth does this mean for space? So I guess that's just where we start. So maybe we just real basic table stakes. What are we referring to when we talk about all this? Like, what is this?
1984, the Supreme Court heard a case called Chevron. And what this case involved is a petitioner came to the Court of Appeals, or the district court in this case, and they had a ruling they didn't like from a federal administrative agency. And because they didn't like it, they were saying that basically, Congress did not give the agency the authority to actually rule in the way it did. The agency argued that the court doesn't have the expertise to decide what this silence in the statute means. And we think we actually have the authority to, where Congress is silent or ambiguous, to actually fill in the blank, so to speak, or, create or fill out the law in a sense and regulate from there. So this got all the way up to the Supreme Court, and the Supreme Court basically said, you know what, we agree with you, federal agency, and we're going to make this little test here for the lower courts to follow from now on. It came to be called the Chevron Deference. And basically what it says is, if a regulation is challenged because of ambiguity or silence by Congress in the federal court under what we call the Administrative Procedures Act, the court's got to look at three things. It's got to look at first, whether or not the actual agency has the force to actually implement the statute. In other words, did Congress give them the authorization to enforce this statute? And if they did, we're going to look at the regulation and look at the statute. And in the first step, if the statute is either silent or ambiguous to it, we're going to look at that and say, okay, if it is, and then we're going to go to step two. And basically what step two says is, you know what, as a court, we would normally look at these things and on our own decide whether or not there was ambiguity or what the silence meant or whether you had the authority to rule on all. But because of the Chevron deference that was decided in Chevron, we're going to look to the administrative agency and you're going to tell us, you know what do you think it says? And the administrative agency will tell us what in their opinion, what it means. And if we, quote, find that reasonable, the court says we're going to have to say, okay, we agree with you and we'll rule in your favor because of that. So in other words, what the Chevron deference did, and what Chevron did in general, was it took the power of the court to review these cases on its own with its own eyes and actually deferred to the administrative agency's interpretation of a silence or an ambiguity in a law that authorized them to regulate in the first place. So in other words, Chevron basically put a thumb on the scale. And it gave a lot of power to basically unelected officials, to a bureaucracy, to the administrative state. It did, instead of allowing the courts to actually decide these things on their own.
I appreciate that. And so with Loper Bright Enterprises versus Raimondo, which that decision came down not that long ago in 2024, Chevron deference has basically gone away, is my understanding. Again, I'm not a lawyer, a legal expert, but my in a nutshell understanding is that no longer is valid. So, so there are a lot of federal agencies involved when it comes to different areas of space. Is this a cataclysmic change overnight? Is this something where, we're going to be starting to see decisions taking longer as they need to go through the courts? I mean, what is this actually going to look like now that deference is not in play?
We're going to see actually administrative agencies, including those that authorize commercial space activities, having to really point to an actual statute. And let me give you an example. The Federal Communications Commission licenses space activities that involve spectrum, the radio spectrum, which they regulate for satellite TV, satellite radio, and other communications. They basically have authority to regulate and license those types of activities. Now, Congress gave them this authority under the Communications Act of 1934. And one of the things the FCC has done since I believe it's 2020, they said because we think we have the power to license these space activities, these involving radio spectrum, we also have the power to regulate what we call orbital space debris. In other words, we can require you to submit a plan to dispose of your satellites when they're done, and other things, including, saying you have 5 years to get your satellite out of orbit after it fails, after it's no longer functional. But the thing is, in the Communications Act, there is no specific authority that says anything about orbital debris. Instead, what happened is the FCC pointed to a portion in the Communications Act that basically gives them the power to regulate anything that is in the public interest or that the FCC feels is there to protect the public sector. So this says nothing about it. They've been regulating space debris or orbital debris through their licensing power for the past 20 years. Now what happens with Chevron overruled by Loper Brightside, if a petitioner challenges the FCC and the FCC says, we want you to do this or we're going to make this rule. Now if they challenge that in federal court under the Administrative Procedures Act, the court can look at this with its own eyes and say, you know what, FCC, there is nothing explicit here, authority that gives you this ability to regulate orbital debris. Where are you getting this? And because they don't have that power of the Chevron deference anymore, the court could probably say, you know what, you don't have the authority, and throw it out. Now, what does this mean? It means that if the FCC wants to regulate, Congress has to step in and basically do its job and put that language explicitly in the Communications Act and give the FCC that authority. Loper Brightside does two things. One, it gives the courts back their power to review it, and be independent in their reviews without having the thumb on the scale by federal administrative agencies. But it also puts the onus on Congress. You got to start specifically, explicitly giving these administrative agencies the authority to do it. It's what we call separation of powers. In other words, the executive branch, the legislative branch, and the judiciary, they all have their function to keep each other in check. What Chevron did is it basically put the thumb on the scale and gave the executive branch more power than it was supposed to have, and basically left Congress, lazy in a sense, because they weren't explicitly telling these agencies, you will give you this authority, or saying you don't have this authority.
Yeah, it completely makes sense. The FCC was a great example because, a lot of people do often ask, what on earth is the FCC doing about orbital debris, and why? Why is that their thing? So I guess the question is, in my mind, in this specific example, if what you were walking us through were to happen and in Congress does nothing, then because Congress being what it is, what would happen in that case? Is it just, I'm wondering, is it gridlock or what? Where does that go?
Well, it depends on whether a petitioner, let's say I am company XYZ and I'm going to launch a communication satellite. I go to apply to the FCC for a license to use spectrum, and basically they're going to be my primary authority to license my space activity because I'm dealing with the radio spectrum. The FCC is going to review my plan and say, you know what, you got to have this orbital debris plan. Oh, by the way, we're making these new rules about orbital debris you've got to comply with. Now, you know what, I may not be upset about, doing an orbital debris mitigation plan because, well, it's a good thing. But on the other hand, this new requirement that they just pulled out of the air, which they actually did that last year, they pulled a 5-year rule out of their hats. This is going to be onerous for me. It's going to cost me money. I mean, I'm going to have to make some plans for the future about this. I don't think this is a good thing. So first step is I have to, file for a motion for reconsideration with the FCC saying, look, you know what, we want you to reconsider this. The FCC will probably say no. Then I would go to the Federal District Court or the Court of Appeals and file a suit under the Administrative Procedures Act. I would basically allege, you know what, the FCC does not have the authority to tell me that I have to abide by this 5-year rule because there's nothing in the Communications Act that says it. Now, the court, with fresh eyes and being able to act as an independent body and not having the thumb on the scale, they might look at that and say, you know what, FCC, show me where in the Communications Act you have this authority. And they would point back to that very ambiguous provision where it's absolutely silent on orbital debris and say, well, we use this. And the court says, but I don't see anything about orbital debris that says anything about satellites, orbital debris, what have you. You don't have the authority to do this. And basically the court say, you know what, the 5-year rule is, basically unconstitutional because the FCC does not have the authority to actually regulate orbital debris. So that could basically bring the whole house of cards on their ability to regulate orbital debris down, right? Make it a big mess. So what would happen then? Congress would have to act. Congress say, you know what, this is important. We got to pass an amendment to the Communications Act. And this will give Congress the ability to say to the FCC, we're going to give you this authority, but at the same time, we want you to coordinate with other agencies when you make these orbital debris rules so there's consistency throughout the federal government, because that's been an issue in the past.
We'll be right back after this quick break.
Most of our listeners who deal with legacy privileged access management products know they tend to be expensive, difficult to deploy, and hard to use. Keeper Security is the answer. Keeper's Zero Trust solution delivers password, secrets, and connection management in one easy-to-use platform. It's fast to deploy, agentless, clientless, and has no implementation fees. Plus, Keeper is FedRAMP authorized. That's why we trust Keeper to prevent breaches and gain full control over privileged users. Visit keeper.io/cyberwire to schedule a quick demo. That's keeper.io/cyberwire. And thanks to Keeper Security for supporting our podcast.
It's a fascinating case study to be thinking through because I imagine a lot of federal agencies are very busy right now trying to figure out what kind of language they might want if they are advocating for something being put through by Congress. I imagine there's a lot of very busy people right now. What about the FAA? So you were talking about the FCC. FAA is the other another agency that's very busy when it comes to space activities. I'm thinking with launch. Does the removal of Chevron Deference change things drastically there?
It might, because basically, the FAA is regulated under Title 51 of Chapter 509 of the United States Code. It allows them to grant a launch license and a reentry license. So I got to apply to go through the regulations they have, apply to it for a launch license. And you know what? I might actually have a capsule that I'm going to put up there that I'm going to want to return to Earth. So I'm going to have to apply for a reentry license. All those are actually authorized by Congress in Title 51, Chapter 509 of the U.S. Code. They have specific authorization for that. However, they don't have this thing called what's called on-orbit authority. In other words, they can regulate launch and reentry, but they can't regulate the activities in between launch and reentry. In other words, once my capsule's up there, I can start doing handstands, spinning around in orbit and, doing all kinds of crazy stuff. This is hypothetical. The FAA really can't say anything because they don't have authority to regulate in between launch and reentry. They've been asking for on-orbit authority for years, but Congress has been reluctant to give it to them. I think it was last year, Congress required a report of the FAA saying, look, we're concerned about orbital debris. Tell us whether you have, based on your launch and reentry authorizations, how you could mitigate, say, upper stages. In other words, these second stages that actually put satellites or spacecraft into orbit. These tend to stay in orbit, and they cause big problems, more than ASAT tests or anything else. So tell us what authority you think you have about requiring these things to be deorbited in a reasonable amount of time. Well, the way I see it, the FCC took that as a blanket authority to say, oh, we're going to create this new rule. And it isn't a rule yet, but it's in the process of becoming a rule, saying we're going to require launch providers to deorbit their upper stages within an X amount of time. You have to bring them back in. And we're going to use our launch and reentry regulations, but we're also going to use this very innocuous regulation that allows us to regulate activities based on national security concerns and public safety, much like the Communications Act that the FCC uses to basically say we can actually compel launch companies to do this. There's that ambiguity again. Now, this regulation has been implemented, but if it does, a launch company could say, you know what? I don't like this. I don't like the government telling me, because I don't think they have this authority. I think this is on-orbit authority, which I do think it is. I could file a suit under the Administrative Procedures Act once the statute is actually, the regulation is actually implemented. Go to the court and say, you know what? The Title 51, Chapter 509 is completely silent on the issue of orbital space debris. It says nothing about it. And there's a lot of ambiguity about the statute the FAA is trying to use. I don't think they have the authority to institute this regulation. Now, if it was Chevron, if we were in Chevron days, the court would say, you know what, we're going to talk to the FAA, think if their interpretation is reasonable, and we'll go with what they say. But we're not in Chevron anymore, so the court can basically look at it with its own eyes saying, what are you guys talking about? You don't have any authority to do this. Congress has not authorized you to do this. Said, toss it out. So again, what is the way of solving this? Congress again. Congress has got to step up and basically say, you know what, we're going to give you this authority. Now, people say, well, Congress is slow, Congress won't do this.
Yeah,
Yep. But there's one other agency, the National Oceanographic and Atmospheric Administration. They regulate space activities to the extent, say I want to launch a satellite, I'm going to put a camera on it, and I want to look at the Earth. I got to get permission from NOAA in order to do that. So if the primary purpose of my space mission is to photograph the Earth, take pictures of the Earth, NOAA has primary authorization. They're the ones who issue the license for the primary activity. Interestingly, just recently, I think probably 1 or 2 years ago, NOAA's what we call remote sensing statutes were updated, and basically they put in this little clause in Title 51, Chapter 64, I think it is. I'm not sure if that's got one, but basically there is a specific statute that says NOAA has the authority to require any satellites launched under its authority, actually require them to be, re-entered within a certain amount of time, to be determined at the discretion of the agency. So here, Congress has explicitly given an agency to regulate orbital space debris and require an operator under their license to say you got to get that out of orbit within a certain amount of time after it's not working anymore. So it does work, but the thing is, Congress has got to jump in and put it in. The whole idea behind this is separation of powers in the Constitution. The founding fathers were very explicit when they designed the executive branch, the Congress, and the judiciary, that they be co-equal branches, and that one branch doesn't have more authority than another. So administrative agencies fall under the executive branch. Congress creates legislation that authorizes what these administrative agencies can do, but they got to follow it explicitly. And that's what these cases, along with another one called West Virginia versus EPA, which was decided a couple of years ago, those two are basically saying to the agencies, you can't just pull these regulations out of your hat and look at an ambiguous section of a statute. Congress has to explicitly authorize that authority. You can't just make it up.
I greatly appreciate this explanation. And a question that comes up a lot when I speak to people who are, a question I am thinking of right now is, the issue of regulatory burden is a big one in space. This patchwork quilt of who you have to go to for certain activities is confusing and difficult, especially for smaller orgs. This is just hypothetical, but do we think that the regulatory burden will be eased at all through the removal of the Chevron deference, or do you think it's sort of not even applicable in this case?
That depends, because there's a bill in Congress right now that wants to revamp, actually shift the authorizing authority to, say, the Department of Commerce, and it's basically HR 6131, and that's currently in this Congress. If you can read it, they want to take the current licensing scheme give them a lot more authority, including dealing with orbital space debris. However, the National Space Council, through the White House, came up with their own idea what they want to see, which completely dismantles what we have now and creates a whole new system. And it's going to be an absolute nightmare if it gets implemented, which it probably won't. I don't think either of them will actually see the light of day. That bill is going to die for sure at the end of the year at this rate. And I don't think you're going to see the White House's version of what they want to see actually come to fruition. So you have on one side where Congress is trying to make things a lot more streamlined and simpler. And I think what the White House and National Space Council want to do is create a whole new monstrosity that's going to make things immensely more difficult and expensive for private operators to actually perform space activities.
Okay, so it sounds like totally different lane anyway. Yeah, I remember reading about
It's politics.
What will make things easier for people while also making sure, people are still safe? It's going to be very interesting to see as things sort of the knock-on effect, but also as things sort of start to trickle through with Chevron Deference being gone now, when we see lawsuits coming through and if how that may or may not change things. And then if Congress will, as you say, do their jobs and actually, give, agencies authority if they so deem, necessary. So, it's going to be very interesting few years.
Well,
I'm sure.
Here's the thing. This is, Loper Brightside is not a magic bullet that's going to automatically, change everything overnight. Somebody has to step up and actually file a suit in court because that's the way our system works. They got to challenge it. Now the question is, if I'm trying to get my space mission license through, say, the FCC or the FAA, do I really want to upset the apple cart right now and make people unhappy and have them and potentially get some blowback and have them delay my mission, or do I want to just stand up and say, what, this has got to be faced. We have the legal ammunition now. We're going to go in and we're going to challenge it. So it's a matter of a company stepping up and deciding whether it makes business sense for them to actually challenge this or not.
I have a feeling a lot of us are placing bets on what company that might be that would do that. I
can think of one.
I can think of one. Yes, same here. I'm just wondering when that shoe will drop, but I think a lot of us are more counting on the days.
It may drop pretty soon.
I would not be surprised, honestly. Michael, this has been a very illuminating conversation. Thank you so much. I know this would honestly take many hours to properly dive into, so I appreciate you're giving me a very high-level overview of a very complex area. I mean, not to minimize this at all. Is there anything else that we want to make sure that people hear? Because again, we're giving people a very basic primer here. Anything else that people should know about what we've been talking about?
Well, there is a good prime. We have this service called the Congressional Research Service, and they put out reports on many topics. And they actually put out a research report last year on the Chevron doctrine, on the Chevron Deference, and the Chevron itself. Actually, if you read my article in the Space Review, there are links to that actual report, and it gives you a good overview. I mean, it is still pretty high level and pretty dense. But if you're curious about what the Chevron Deference is all about, that would be a good thing to read. Also, please read my article. I talk more in detail about what we've discussed here, and but what I want people to understand is this stuff's complicated, but it's one of those things. People like myself are there to actually do the behind the scenes work so that things are pretty much, so you can watch your cable TV and not have to think about all this stuff. We're the ones who have the headaches for it and deal with it.
That's it for T-Minus Deep Space, brought to you by N2K Cyberwire. We'd love to know what you think of this podcast. You can email us at space@n2k.com or submit the survey in the show notes. Your feedback ensures we deliver the information that keeps you a step ahead in this rapidly changing space industry. T-Minus Deep Space is produced by Alice Caruth. Our associate producer is Liz Stokes. We are mixed by Elliot Peltzman and Trey Hester, with original music by Elliot Peltzman. Our executive producer is Jennifer Iben. Our executive editor is Brandon Karpf. Simone Petrella is our president. Peter Kilpie is our publisher. And I am your host, Maria Varmazes. Thanks for listening. We'll see you next time.
This September 18th and 19th in Denver, a tight community of leading experts is gathering to tackle the toughest cybersecurity challenges we face. It's happening at MWise, the unique conference built by practitioners for practitioners. Brought to you by Mandiant, now part of Google Cloud, MWise features one-to-one access with industry experts and fresh insights into the topics that matter most, right now, to frontline practitioners. Register early and save at mwise.io/cyberwire. That's mwise.io/cyberwire.